Welcome back. This is the first in a series of two podcasts in which I converse with Professor John Marquise about legislation and its importance in the Canadian legal system. In this first podcast, we examine how it is that an idea goes from idea to law, and more specifically, we examine the legislative process at the federal and provincial level. I began by asking Professor Keyes about his background and career.
Well, wonderful to be here, Craig. My name is John Marquise. I'm an adjunct professor here at the University of Ottawa, which is to say I've sort of been part-time teaching for quite a number of years. I started teaching in the about 1985-86. I also, on an exchange with my employer at the Department of Justice, I taught here full-time for 3 years at various points through the 90s and the early 2000s. My day job through all of that was working for the Department of Justice, the Legislative Services Branch, which is a part of justice that is responsible for drafting laws, federal laws, basically bills for Parliament and draft regulations for a whole range of bodies that make regulations.
So one of the things that you work in, one of the areas you work in and are well renowned for is the area of statutory interpretation. So I thought maybe we'd start by just making sure that everyone understands what we mean by a legislation, and then within the subset of legislation, what we mean by a statute. Perhaps you could answer that question.
Great starting point, although a surprisingly complicated starting point, or it can be, but I'll try to give a fairly succinct answer. Basically, when we talk about statutory interpretation, that encompasses acts of Parliament. And so you have acts of the federal Parliament, you also have acts of the provincial legislatures, and that's a bit of a shifting terminology that we generally in Canada talk about the provincial legislatures, but we talk about the federal Parliament. But essentially, they are the same kind of lawmaking body. They make statutes, or another word for that is act. But statutory interpretation also applies to other legislative sorts of documents. And there's a whole second layer of legislation that we call delegated legislation or subordinate legislation, or often goes by the name of regulation or rules or bylaw. And this is another form of law, but it's made by some delegated authority that has that authority passed on to them through an act of Parliament. In terms of regulations, the delegated authorities are very often the cabinet or individual ministers, or it may be particular agencies, bodies like the CRTC or the National Energy Board, which have this delegated authority in an act of Parliament to make additional legislation to supplement the act of Parliament. Another really significant delegated actor are municipal councils, cities, towns. Bylaws, municipal bylaws are another really significant form of law, another form of delegated legislation.
And so statutes then are almost the top of the pile. Statutes then, the voice of the legislature is what authorizes these other bodies to make whatever regulations, orders, bylaws that they're authorized to do. And so at some point, presumably, if you're purporting to issue a regulation, you have to find authority for that regulation in some statute somewhere. Is that correct?
That's exactly right. There are a few slender remnants of prerogative authority to make rules, but they are really very, very slender. The only significant one that I know of is the Canadian Passports Order, because passports have never been made subject to an act of Parliament. It's a facet of the prerogative over foreign affairs. And so the rules about the issuance of passports are still made under the prerogative, but that's really the only significant form of regulation that's made at that level. Under the prerogative, virtually everything else is made through authority that has been delegated in an act of Parliament.
So let's focus on those acts of Parliament. How does an act come about?
Well, formally speaking, acts in the parliamentary system, and that's the system that we have in Canada, All the provincial legislatures and the territorial legislatures follow it, and of course the federal parliament does. In that system, you have what are known as a series of readings of a bill. A bill is a draft law. It's a proposed law, and that bill is introduced in a house of the legislature or a house of parliament. It is given 3 readings, which are really actually only 2 of them are opportunities for debate. The first reading is really to get the ball rolling. It's pro forma. It's simply to announce that a bill is there in front of the legislature. The second reading is really the first chance for some debate about whether the House should pass the bill or not. And then third reading is the last chance for debate. In between second and third reading, very often you also have a bill sent to a committee for study. And when the committee studies the bill, it usually begins by hearing witnesses to talk about the bill, and the lead witness is usually the member of parliament who introduced the bill, and if that member of parliament is a government minister, usually the minister is accompanied or followed by government officials who were involved in the preparation of that bill as well. So that's the basic set of steps going through the parliamentary procedure. In all of the provincial or territorial cases, there's only one house of assembly. And so the provincial bills, the territorial bills just go through the 3 readings, and then they are ready for final approval, which is known as royal assent, and that's given by the Lieutenant Governor. At the federal level, we of course have 2 houses. We have the House of Commons and we have the Senate. And so a bill has to go through one house first, and then it has to go through the second house. And basically the procedure is much the same in the second house. And both of those houses have to agree on the bill. If one of the houses decides to amend the bill after the other one has finished with it, then those amendments have to go back to the first house. And actually that's something I should have mentioned a moment ago when I was talking about committee study, is that something a committee can do is it can amend the bill. And so it can report the bill back to the House with those amendments. And then the final opportunity for additional amendments usually occurs at third reading. So the bill that emerges from that process is not necessarily the same as the bill that entered that process.
Is there any rule at the federal level which House can take a first charge of which sorts of bills? Is there a rule on where one introduces certain sorts of bills?
Yes, there are some rules that focus on bills that have to do with either the imposition of taxation or the spending of public money. So bills that basically deal with money have to originate in the House of Commons, in the lower house. And it's one of the fundamental prerogatives of the House of Commons. It's one of the features of the way our law deals with taxation measures, recognizing that taxation is something that should come from the people, from the representatives of the people, and the House of Commons is the body that has the most direct connection to representing the people. So as long as a bill does not deal with taxation or spending, it can be introduced in either house. But all the spending and the taxation bills are always begin their journey in the House of Commons.
People sometimes talk about government bills and private members' bills. What are the differences?
A government bill is one that is introduced by a cabinet minister. It's introduced on behalf of the government. And when I speak of the government here, I'm really focusing on the cabinet, the prime minister or the premier, and the other ministers who are part of that cabinet, that basically inner circle of advisors to the Governor General or to the Lieutenant Governor. And those ministers are the ones who control the apparatus, the executive apparatus of government. They control government departments, and they also control the agenda of the government in the House. So bills may be introduced basically on behalf of the executive, on behalf of the cabinet, and those are typically known as government bills. Private members' bills are ones introduced by other members of Parliament or other members of the Assembly. And those members can be members of the opposition, but they can also be members of the governing party, but they're not part of the cabinet. So they're not cabinet ministers. Another word for them is backbenchers. They support the party. They help compose the majority that the government needs to maintain to maintain the confidence of the House, but they're not appointed to the executive. But they, like all other members of Parliament, have the ability to introduce or propose laws, propose bills in the legislature, and their bills are known as private members' bills.
Where do the ideas for these law projects come from?
They can come from just about anywhere, and with government bills, they often originate in the election platform of the party that is elected to power, and that's typically what happens once a new party comes to power. The first thing it does is it starts to implement the agenda that it campaigned on. And so all of those promises, if they required legislation, usually start to appear as government bills that might wind their way through the House. Of course, as time goes on, the government looks for other sources of ideas, and those ideas are as varied as can be. They may be ideas that come up through the party, or they may simply be ideas that come up through constituents. Individual elected members of the party may generate ideas from their constituents, and they suggest them to the government, and they may end up being part of the government program. Another great source of ideas is the public service, the bureaucracy. The public servants who are there to support ministers in their departments. And especially since most legislation these days requires a certain amount of administration, the public service is a very vital source of ideas on proposals for legislation, proposals for improving the administration of government programs. The public service is also a source of expertise on the various issues that typically come up. The public service, because we have a professional public service in Canada, they have a history, they have very long-standing knowledge of these issues and how they've been dealt with through time. And so they bring all of that experience as well to the generation of new ideas for Parliament.
Is there a difference in the rate of success in Parliament of private members versus government bills?
Yes, there has been a very significant difference between those. Historically, very, very few private members' bills would be passed. You would perhaps get one or two a year at the federal level, and at the provincial level, I think there are instances where a year or two would pass and there would be no private members' bills passed. But about 20 years ago at the federal level, members of Parliament began, the backbench members of Parliament, began lobbying for more opportunities to have their bills dealt with. And the reason that historically that private members' bills were not passed is that the parliamentary agenda is controlled by the government. And of course, the government wants to make sure that its own business is taken care of before it allows time for other business. And that meant that up until about 15, 20 years ago, almost all of the business of Parliament was devoted to the government's questions and not devoted to the private members. Things changed federally about 15 years ago with some gradual changes to the rules of the House, which began to guarantee a certain amount of time had to be devoted to private members' business. And in addition, federally, a lottery system was set up for private members' business because, today you have 360 members of Parliament, and so of those, probably 330 are backbench members of Parliament. That's potentially a lot of private members' business, and the government business still has to get done. And so in order to come up with a fair system for dealing with that private member's business, a lottery was created. And so at the beginning of each session, the names of members of parliament are drawn, and the top 30, the first 30, then go on the roster for having their items dealt with. And those items can be bills, or sometimes they are resolutions as well. It doesn't matter. It's up to the member of parliament to decide how they want to use their time if their name gets drawn. And so what we have now federally is a system that devotes each day a certain amount of time to that private member's business. And so over the course of a few weeks, all of the business of those 30 members gets dealt with. Now, of course, an hour of debate is probably not enough to deal with the item, and so once you have your hour, you drop to the bottom of the list of 30, and then gradually you work your way up again. But the result of this system is that far more private members' bills are being passed than ever before. So we're up to somewhere between 5 and 10 private members' bills a year now, which is still relatively minor in comparison to the vast bulk of government business, but it's really a distinct improvement over the way things used to be.
You mentioned that the final stage whereby a bill becomes an act or a statute is something called royal assent. What's that?
Royal assent recognizes that an act of parliament, first of all, it recognizes that the concept of parliament itself is really a composite entity. And so at the federal level, there are three components to the Parliament. One is the House of Commons, the second one is the Senate, but the third one is the Crown, represented by the Governor-General. And for a bill to become law, it requires the agreement of all three of those. And essentially the role of the Senate and the House of Commons is to advise the Governor-General to accept a bill. And so that's the final stage of a bill. Once it is passed both houses, it then goes to the Governor-General for the final royal assent. And historically that's been done through a ceremony that takes place in the Senate chamber. But about 10 years ago, a statute was passed to provide for a paper assent, as it were. And so very often now bills are assented to simply by the signature of the Governor-General, or it can also be the signature of one of the delegates of the Governor-General. And those delegates are the judges of the Supreme Court of Canada. And that, again, is a recognition. It says something about the nature of this role, that it's really a formal role. It's not substantive. It would be unthinkable for the Governor-General to refuse to give assent to a bill that had passed through the House of Commons and passed through the Senate. But it's still a very important symbolic role that recognizes that this law is something that comes from the Crown as the embodiment of the state. At the provincial level, where you only have one house, one assembly, the bills go through that assembly, and then they are presented to the lieutenant governors for their assent, and it's the same role that they discharge as the Governor-General federally.
With that, John Marquis and I completed our conversation about the legislative process. In the next podcast, we'll discuss how it is that one is to read this legislation. How is it that one interprets a statute?